Good morning, everyone. My name is Brett Knight with the Law Office of Fry, Knight and Looper, and I'm an attorney here in Tennessee. And going to continue having our conversations that we typically have in the mornings before the start of the day over a cup of coffee and talk about what's going on in the legal news, what's legally relevant and going on. And we typically focus on local issues here in Tennessee, but they probably sometimes have an impact on the national level as well. Today I wanted to kind of just spend a few minutes talking about the criminal justice reform that has recently passed here in Tennessee and that goes into effect here later this week. The criminal justice reform, the Governor Bill Lee pushed pretty heavily and got passed really easily through the state legislature, and it was signed back in May 12th of 2021, and it goes into effect on July 1st of 2021, which again is here just in a few days, time that I'm recording this. So this is about to go into effect, so I thought it might be good to talk about it. Now, I'm just going to go ahead and say right here in the very beginning that I'm going to brush it the best that I can in very broad strokes. It's a very complicated statute. It's many faceted. It has lots of information about funding and other stuff in it, but I'm going to try to get to the meat of the matter and talk to you about what does criminal justice reform look like here in Tennessee. Some of you might be interested from a purely just interested from the standpoint of how this legislation is passed. Some will be interested because it will affect your communities, and some might be interested because you or your loved ones might currently be in the system and looking to see how this affects you. So what is the Criminal Justice Reform Act and how is it going to impact us in Tennessee? I'll refer to my notes from time to time the best that I can. So it's public chapter number 409. And then also there's a companion public chapter 410, which is the Reentry Success Act of 2021. I'm going to refer to them both together just as a classification as Justice Reform Act, just for convenience. And again, they were signed on May 12th. So the first thing we'll talk about is, and I think what the biggest impact is, we'll just jump straight to what I think the biggest impact is, the major changes that this brings to probation in the state of Tennessee. Most of you know what probation is. It's an alternative to serving a sentence if you're convicted of a crime. So let's say, for example, that Joe Smith is convicted of a crime and the crime has a possible punishment of, say it's a Class A misdemeanor, possible punishment up to 11 months, 29 days in jail. And he pleads guilty to it and he's sentenced to 11 months and 29 days. However, either through a plea agreement or through the judge's sentencing, instead of serving that 11 months and 29 days in jail, he's going to serve it on probation, which means he's going to be out in the community. He's going to have a probation officer to report to. He'll have other stipulations as part of his probation. He can have searches upon himself and his property while he's on probation. He'll submit to random drug screens, and he's not allowed to break the law or associate with other people who are felons. So there's several conditions placed on you while you're on this probationary period. If you successfully complete it, and most people do, then you've completed your punishment and without having to be in jail. It's good for you, good for our fake client here, and it's also good for the community and the fact that they're not having to pay for that incarceration for somebody who's of minimal risk to the community. So that's what probation is. So what are the changes? And I will just go ahead and say these are major changes. All the changes that this criminal justice reform represents is probably the largest and most sweeping changes to the criminal justice system that I've seen, I'd say, in a generation at least. So it is quite impactful. First of all, the trial judges are given some very strong language as far as what the legislature expects out of them. And I'll read this one from it. It says that the trial judge shall. Now, anytime you're dealing with legal writing, the word shall, that's not just a random word that's used. When the word shall is used, that means there's no discretion, that you must, under all circumstances, adhere to what follows. So, the trial judge shall not revoke probation upon a first technical violation. Okay, technical violation used to be some language that we often use, but it was kind of more informal. It wasn't so much form. Now it's very formalized. So first thing that we're going to recognize is that we now have two kinds of violations of probation. And again, a violation of probation are those conditions that I talked about earlier. let's say, for example, that our random person, let's say this time is Jane Brown. Jane Brown's on probation, and Jane Brown does something violates the conditions of her probation. Let's say she picks up a new charge, or let's say she fails a drug screen, or any of the other things that she's not allowed to do. Well, now we have two separate categories of violation. We have what we refer to as technical violations and non-technical violations, and they're going to get treated very different. So what is a technical violation? And I'm just going to read this straight off the statute here for you. This is in section 24, subpart 3, where it says, as used in this subsection, a technical violation means an act that violates the terms and conditions of probation but does not constitute a new felony, first, a new Class A misdemeanor, zero tolerance violation as defined by the Department of Corrections Community Service Sanction Matrix, or absconding. Okay, so we now have a category called technical violation, which means any violation except one of these four. So those four would be non-technical violations. And again, it's either new felony, Class A misdemeanor, violating a zero tolerance condition, we'll talk about that in a second, or absconding. Absconding is simply meaning you quit reporting, you just left, and you were unaccounted for while you were on probation. So that's what absconding means. So you've got these four major violations over here in the non-technical, and then everything else falls in the technical violation. So what we're being told then by this statute is that if you committed one of these technical violations, which is kind of the larger pool of things, you cannot be, the judge cannot make you serve that sentence on a first technical violation. That's what the statute says when it says that the trial judge shall not revoke probation based upon one technical violation. See, in the past, that was kind of the teeth or the axe hanging over somebody's head, is that if you did any violation of a probation, you could be sent to jail, either for part of the sentence or all of it. You might go for 30 days or 60 days or 90 days. You may be revoked for the entire sentence. Sentence could be you could have a 6-year sentence hanging over your head, and if you violate, all of a sudden now you're serving it. And that was kind of the teeth that kept people, following the rules of probation. But now we're told through the statute that goes into effect later this week that if it's a first technical violation, the judge shall not send them to jail for that. And then we have a grid of what to do on second and subsequent violations that are technical. So again, we're only talking about technical violations, but let me tell you what it looks like. So we already know that the first violation of a technical nature, first technical violation of probation, the judge cannot make you go back to jail. On a second violation, the judge may, which means he does not have to or she does not have to do this, but could impose a term not to exceed, so this is the maximum that they could impose, on a second technical violation, 15 days in jail. On a third violation, 30 days revocation, which means 30 days in jail. And on a fourth violation, 90 days. And on a fifth or subsequent violation, then they could revoke. And I'll tell you, I've never seen a fifth violation prior to this statute going into effect, so that's quite a lot of tolerance that's being put there. And again, so now we know if it's a technical violation, we've defined what that is, the legislatures have defined for us this larger category, then you can't be revoked to serve the full sentence unless it's a fifth or subsequent violation. So a lot of leeway being given and a lot of instructions being given. It's a huge deviation from the norm from where we are currently right now. So that's technical violation. So what are the non-technical? Again, non-technical means that you either committed a felony while on probation, committed a Class A misdemeanor while you're on probation, or you've absconded, or you've done one of these zero tolerance. So let's talk just real fast to kind of wrap this up. What is a zero tolerance issue? So that we kind of know the whole category that you can be revoked on the first offense. Possession of a firearm while you're not allowed to have one. A positive drug screen for methamphetamine. This is a big one. We're going to come back to that. Positive drug screen for methamphetamine. 3 non-compliances in 1 year, 2. There's a lot of these compliance issues that fall within the matrix. And refusal to submit to a search. And then Class A misdemeanors or felonies, which we've already covered. So essentially, other than the noncompliances and the Class A misdemeanor and the felony, which we've already discussed and they're enumerated in the statute, what it really says is possession of a firearm by somebody who's not allowed to have one, not submitting to a residence search, which is interesting that it specifically says residence search because, my defense attorney brain kicks in and says, that doesn't say search of a person, that says residence search. So there'll be some issues to wear out on that, I'm sure. And a positive drug screen for methamphetamine. Okay, so why do I think that's a big deal? It's not a big deal what was just listed. Nothing on there surprises me that could be a non-technical violation and one of the zero tolerance issues. What surprises me is what's not on there. And that is any positive drug test other than methamphetamine. So what that means is, and this is probably the most shocking of it all, so if I had to get to the point that is probably going to be surprising to most citizens here in the community, is now a positive drug screen for anything other than methamphetamine is categorized as a technical violation, which means you cannot be revoked to serve on your first. You cannot revoke to serve any time on your first violation. Your second violation is going to be 15 days. And it goes down that list that we just went to. 15 days for a second, 30 days for a third. I'll go back to my list here. 90 days for a fourth. And only on a fifth or subsequent violation can you be revoked to serve your sentence. That is a huge change because I'll just tell you, there's a lot of drug tests that if you came back positive for certain drugs, that most of the judges in this district would revoke you to serve the remainder of your sentence on a first violation if you were with those, and definitely on a second. Heroin, for example. So if you test positive for heroin, let's say you're convicted of a drug charge and you've got a 3-year sentence to serve and you were given probation, and then you tested positive for heroin, there's a lot of judges, matter of fact, most judges in this district would revoke you to serve that entire 3 years, definitely on a second violation. So that is a huge, huge change. So anything other than methamphetamine is a technical violation. Cocaine, heroin, oxycodone, OxyContin, all the Schedule III drugs and prescription drugs that we've had such issues with, fentanyl. None of those are listed as a zero tolerance issue, which means now in the state of Tennessee, if I'm on probation, those are considered technical violations. And that is, again, that's huge change. That's going to cause a rippling effect in our courts. I don't know a single judge that was following a lenient path on dealing with things such as cocaine and heroin as what we are now being told we have to follow by the legislature. So it is a huge change to that. So that's probation. Again, I could spend an hour just talking about all the ramifications of what we just talked about, but that's it on probation. There were also several changes in the Justice Reform Act to bonds, a lot of strong language and guidance to the courts that lowers bonds in most situations. And I think, honestly, I think that was very reasonable what they've done. A bond is the amount of money you put up in order to ensure your appearance back at court for your court proceedings, so you don't have to spend that entire time in jail while you're going through the court process. Again, its primary goal is to ensure that a person is going to show up to jail, or not to jail, to court. We want to make sure that people are showing up to their court dates and such. So, and sometimes it is attempted to be used as punitive, and that's not the purpose. So I think the language kind of clarifies that, gives some good language for us to use in bond hearings to get bonds lowered. And it also removes bonds on certain occasions, that it orders that on certain charges that there should not be a bond, what we call an ROR, a release on own recognizance, such as driving without a license if you've lost your license due to the fact that you didn't pay fines or fees or something. So it makes sense to me in that category, not nearly as shocking or provocative as the changes to probation status. There's also a major focus on treatment in this Justice Reform Act, something that I've seen work very well in the court system. As many of you know, I was a prosecutor before I was a defense attorney. I've seen this on both sides. I've seen the success stories. I've seen how addiction plagues our community. I've seen how good treatment programs work and how they can change people's lives and get them out of the system permanently. So I'm a big advocate for good treatment programs. good long-term treatment programs, good residential long-term treatment programs. I'll be very, very specific on what I think works. These long-term residential, where you take people out of the community and out of the people who are influencing them for a longer period of time, let them rebuild new cycles and new patterns while learning how to treat their addiction. So that I'm a big fan of those. So we see a lot more funding coming in these bills. Very strong language for the judge to allow this. The judge is being told to strongly consider allowing treatment. It's a much stronger language than what we've ever had before. And honestly, we've kind of seen a shift, and I think this will be challenged a bit. We'll see this over the next several months because people don't like when power is taken away from them. But I think we've seen a shift where no longer is it a position where a defendant is seeking permission from the state to be allowed to go to treatment, as much as it is, if it's been determined by a medical professional that they would benefit from treatment, that the judge shall strongly consider it. And honestly, that's the only thing that's being put in the statute, which means allowing the state and the DA's office to basically say, I'm going to veto this person going to treatment because I don't like them or because of what other conditions. Those look like they're gone. We'll see if that is truly how it works. But I talked with a few judges, a few prosecutors, a lot of defense attorneys. We pretty much all read it the same way. We'll see how it's enacted. Every court has different people, and we'll see how it's enacted across the board. But I do believe we're seeing that shift go from, if a person can benefit from treatment and that they want treatment, that they should be allowed to have that, and that there should be funding there to help that. And it's money well spent, in my personal opinion. So that's where we are. I mean, it is a huge change in policy and criminal justice reform. This is a longer video than my normal coffee talks are, and I just touched the surface of it. I'd be glad to talk with anybody if you got specific questions about it, but I wanted to kind of throw this out there. I know it was in the news a lot, but nobody ever really kind of dove into it. It's very complicated, but I'd be glad to share information with somebody if they wanted to dig into it more. I spent many hours kind of digging into this and thinking about the ramifications. I think it's within the Tennessee Constitution. I think it's in line with the U.S. Constitution. That's important to me, important to our system. So I'm a fan of the effort. I'm not so sure about all the details of it. It is a drastic change for our system. So let me know what you think. Tell me what your views are of it. And, we always have good, respectful conversations here. So I'm always encouraged and when I see other people's comments. So anyway, well, I hope you all have a great day. I got to get to my meetings today and get going on it. But I appreciate you tuning in. I hope you found this information useful on the Justice Reform Act here in Tennessee in 2021 that will take effect on July 1st. You all have a great day.